The Supreme Court of India has sounded a clear warning on the misuse of the POCSO Act, saying a law crafted to protect children is increasingly being turned into a tool to criminalize consensual teenage relationships and settle personal scores. Hearing a case from Uttar Pradesh, the court observed that mechanical application of POCSO is causing deep and lasting harm to young lives. The two-judge bench underlined that the Act represents one of the most solemn promises of justice for children, but it cautioned that when such a powerful law is applied without nuance, it risks punishing those it was meant to protect and eroding public confidence in the justice system itself. The judges pointed to a disturbing pattern where adolescent relationships are reframed as sexual offences, often driven by family opposition or social pressures. The impact, the court noted, goes far beyond the courtroom, leading to trauma, institutionalization, and long-term disruption to education and identity. To address this, the court asked the centre to consider a limited Romeo-Juliet clause, which happens to be a legal carve-out for consensual, close-in-age adolescent relationships, while making it clear that moral and legal force of POCSO must remain untouched. Abuse, coercion and exploitation, the bench stressed, must continue to be dealt with firmly. The court also highlighted the deeper inequality in access to justice, where the law is sometimes manipulated by the privileged, even as the most vulnerable children remain unheard. As the debate moves to the Parliament now, the message from the Supreme Court of India is unmistakable: protect children fiercely, but ensure the law does not become a weapon against them. We have Jyotika Kalra, advocate, Supreme Court, and former member, National Human Rights Commission, joining us now. We also have IPS Ellen Rao, former DCP, Delhi Police, with us. We have Professor Alok Sharma, women and child rights activist, joining us on the broadcast. Thank you, all of you, for taking time out to be with us. Jyotika Kalra, let me begin with you. A very important observation by the Supreme Court of India on a very important law. Jyotika Kalra, can you hear me?
Yeah, I can hear you.
Please go ahead. I wanted to say this is a landmark observation and a suggestion by the Supreme Court of India on what is a landmark a law in the first place.
Look, I'll just read as to what is the suggestion by the verbatim. I'll read what the suggestion has gone from the Supreme Court. It says that misuse of the POCSO Act highlights a grim societal chasm. On the one hand, children are silenced by fear and their families are constrained by poverty or stigma, meaning thereby that justice remains distant and uncertain. And on the other hand, those equipped with privilege, literacy, social and monetary capitals are able to manipulate the law to their advantage. And what I want to say is that the Supreme Court, while giving these directions to the government of India, has asked them to consider to put in a Romeo-Juliet clause. What is specifically meant by the Romeo-Juliet clauses, I would like to go in a little history before 2013. It was only in 2013 that this consensual sexual activities between the age of 16 and 18, the girl's age, was introduced as a penal clause in rape laws, and 2012 it was introduced as a penal law in POCSO Act. So the question is that before 2013, when IPC was amended, between the age of 16 to 18, the consent of the girl was a relevant factor. If a girl above the age of 16 was a consenting party to the sexual intercourse, that was not considered as a rape. It was only above the age of 16 till the age of 18, if the consent is not there, only in that cases it was a rape, otherwise it was not a rape. But when POCSO was introduced in 2012, POCSO made the definition of the child below the age of 18. So any sexual activity with the child, that is a woman or a man, POCSO is gender neutral, would be considered as a penal act having penal consequences, was considered as a crime. So this is only, it's not very old, but it's only in 2012, followed by 2013, that the consent of the girl didn't matter anymore, and it was considered as a crime. So this has been, and I'll again want to make another point that POCSO is a gender neutral law. So there can be a situation where it's not only where the girl might be below the age of the boy may be below the age of 18, as well as the girl may also be below the age of 18.
Right.
In that case, the girl can be made a victim. That's a very serious condition. A girl can be made not a victim, but will be an accused in that case. So I'll just summarize by saying that when the court has said this, so this is not something which is very unusual, because before 2012 and 13, consent by the girl was not considered as rape. So it's a very valid suggestion. And before that, there were judgments by Delhi High Court also,
Right.
where the High Court has held that why you criminalize the children when they are involving into the sexual activities with their own consent. And if it may be permitted to add a little bit more, because when this amendment was introduced in 2013, I remember Sushma Swaraj, she was member of parliament. She said that we have just made the law as per the marriage law, because the age of the marriage was 18.
Right.
So the mindset was that if we are allowing if we are not criminalizing the sex between the age of 16 and 18, that means we are allowing the adolescent to have sex. So that is the point. That is the reason why this was made a crime, because by leaving that scope, in fact, the parliament thought that we are allowing the adolescent to have sex between the age of 16 and 18, because our age of marriage is 18. Yes.
Right. IPS Ellen Rao, obviously the reason why the Supreme Court had to make this, this kind of an observation is the fact that the repeated pattern of cases of the used case of POCSO being, completely, misused. The reason why the law came into place and the reason why it is being used on a repeated basis, and not just in one state, but across the country.
Good evening, Krishna, to co-panelists and to all your viewers. And this is a very relevant subject to have. It's in a public interest, because it has been observed that POCSO law is being misused, especially between the age of 16 and 18. As Ms. Kala is also pointing out, that in POCSO, no doubt, this age is considered to be the minor. But in some other cases, because POCSO is a special act and it is gender neutral, and that's why this age has been considered as a minor's age below 18. But in other cases, like murder, if somebody commits murder between 16 and 18 years, then it is judged with the mental status of that person. But here in POCSO, no doubt that this age between adolescents, age of 16 to 18, definitely it's being misused because of the POCSO Act, and so many people have been blamed for this offence, even then that it is with the mutual consent and the consent of the women. And that's why the Supreme Court has to come in picture. That
Ellen Rao, my question to you also is that have you seen similar cases, when you were the DCP of Delhi Police?
Yes, definitely. Till I was DCP, then this POCSO was hardly 2 years, 2014. After that, I am practicing lawyer, and I'm dealing with the POCSO cases also. I have so many POCSO cases defending the accused or with the complainant also. Both ways, I'm handling the POCSO matter. But similarly, because the Honorable Supreme Court has rightly pointed out that sometimes this act is being misused, and definitely it is being, because after 16 or 18 years, the girls maybe with the consent involved in some sexual activities with the male, then even then it is considered as a very serious offense. And
Okay.
in this offense, I think bail is also very
Yeah.
difficult to case.
Yeah, yeah. Stay with us. Let me also take this across to Dr. Nisha Khanna, senior psychologist and relationship counselor, who's joined us. Dr. Nisha Khanna, the age of 16 to 18, it's a delta of 2 years, but it makes a world of difference when it comes to law and how harmful a law can be when it gets misused, isn't it?
I think so. We can say that there are the impact of misuse of law, especially on these sorts of kids, have maybe we can put it in the five categories. First, as a self, the child when face such issues, maybe the stigma in the society itself, and they isolate. Isolation you have to face from the sometimes from the family and from the society and also. Second, mental health issues, depression, anxiety, post traumatic stress disorders. So, those issues are very normal when the children face such issues. Third is on the relationship, because trust issues are basically on the question mark on such children face, because when they have to withdraw from the society, because in this Romeo Juliet relationship, most of the time the couple is into the consensual relationship. So, consensual relationship, they trust each other, and when getting influenced by their family members or someone else, and they are filing a case against the partner, so the trust issues are broken completely. So that is again a I would say the intimacy issue a person can also face. The avoidance thing is there, that I have not to make any sort of relationship in future. Maybe someone can break my trust and put me behind bars. Other thing is we can say that education, because when the children face such issues, or these teenagers face such issues, the schools, the what are the studies they are doing, it's a disruption in the education system what they are doing. Socioeconomic status most of the time of such kids, I have seen in myself also that it's not that great. So sometimes they have to face that part also. The aspiration to do something in life is also getting reduced, especially related to a career part. Social functioning, so when you say the social function, it is about the family conflict, community from those ends also they have to face. Sometimes even the onset of parents also and the relatives also make them feel that they have did something very big, where they know that this relationship was consensual. And sometimes the family, as we
Okay.
know that families are using this law to just prove them that we are not approving this relationship.
Yeah. Professor Alok Sharma, let me bring this to you. One is that this is an important law that needs to, the sanctity of which needs to be protected, so that there is no leniency in or leakage in any which way. But at the same time, you're seeing the cases, a number of boys who've been disproportionately punished because of the privileged using the law as leverage.
Yeah, Namaskar, Jyotika ma'am, Krishna ji, and other panelists. Uh, uh, as Jyotika ma'am has already stated, that this was the position when the girl, the consent age was 16 for the girl. And when you see after Nirbhaya case, when the age was increased to 18, many senior professors from our faculty also, they registered their dissent from this point, that many more cases will come, because earlier when the age was 16, then definitely the number of accused persons was less. But when you increase the age from 16 to 18, and that was a compulsion, as ma'am also stated, and I also want to add one more point. What about the medical condition for a woman or her physique, that whether she is ready for these kind of relationship? That is other point, because marriage, when we say marriage age should be at 18, so why should the age for consensual sex be less than 18? But the point is, yes, you are right, because now the generation is changed, and people, the maturity which we used to get at 21 or 22, people are getting it at 16. So this is the problem we are facing. But my concern is that even if we introduce Romeo Juliet clause in the law, then the burden will be on the judiciary, because every time we say we may have n number of provisions in legal laws, we may have any amendments, but what about the implementation? today we are talking about the misuse of the law because people are, indulging in the consensual activities, and parents or the other people are booking boys for this. But what is the guarantee that when the age will be less, whether people will misuse it or not for consensual thing? It may be, under threat or compulsion, and later on they can say it was consensual. So both ways, my suggestion is, whatever law we have, we must emphasize on the implementation part of the law. And judiciary, if we have this clause, definitely judiciary will have to play a more role, because judicial discretion will be there, that under the fact and circumstances, it is for the judges to find out whether the relationship is consensual or not. So heavy burden will be there. Yeah.
Okay, there will be a heavy burden. Let me take this back to Jyotika Kalra. Now the matter moves to the Parliament. This is a suggestion, this is an advisory from the Supreme Court of India, but at the end of the day, it will be up to the Parliament to decide whether to include that Romeo and Juliet clause or not. What more can the Supreme Court do?
Supreme Court can't go beyond the law. That is the helplessness of the court. Court is there only to interpret the law. So law is very clear that below the age of 18, if the sex is there, it is almost a statutory rape. You need not to prove anything else. If sexual intercourse is there, then it is a rape. So as far as was also pointed out by Professor Alok, the question is how to carry it forward, how to implement this law. Because earlier, the consent was the issue, that if it is with consent, it is not rape. Now, if the court has suggested Romeo-Juliet clause, it's not the first time that the Supreme Court has written to the Secretary Law, Government of India, to consider initiation of steps to curb the menace and to introduce the Romeo-Juliet clause. Even earlier judgments, as I said earlier also, have also mentioned about this. Why should we criminalize our adolescent when their sexual activities with consent? So it is for now the Parliament to decide it. Supreme Court can only follow it up as to consider as to what action the government has taken, how that has been considered. Maybe that the matter is referred to the Law Commission. The Law Commission invites suggestions from the general public, and then further opinion is being formed, as has been, because as I said, this is not something which would be new. We had the law for very long, where between the age of 16 to 18, the consent of the girl was relevant. It was only to harmonize it with POCSO and to harmonize it with the marriage laws that this consent segment was removed from the things. But again, because as I said, at that point of time when this consent was not considered relevant for criminalizing the act, the rationale behind was morality. That when we are not permitting marriage below the age of 18, putting this clause, decriminalizing the sex between 16 to 18, may not lead as if the government, as if the law is encouraging immorality. It is perpetuating immorality. That is the area which would have to be addressed. I mean, there would be suggestions on that line also, that if you decriminalize the law of sex between the girl of 16 to 18, it may be that you are encouraging immorality. So that is one thing. And as I said, it is now the ball is in the court of the Government of India to take it further. As I said, it can be referred to Law Commission, the suggestions can be invited, and thereafter the bill may be introduced in the Parliament to amend the POCSO Act as well as the Indian Penal Code, because that also deals with the rape. So it is not only the POCSO, but IPC rape would also have to be reconsidered and amended accordingly.
Okay. IPS Ellen Rao, the law is one thing. The other end of it, you deal with it, which is the implementation of it all, and that will require clear communication from what the law, how it has been amended, and to ensure that false cases don't get filed in police station.
Yes, Krishna, this is the most important problem, that the false cases are being filed under POCSO and other rape also, even Even with adult people, the rape cases also have come to light that these are being falsely, the people are falsely involved because of to settling their score. In some of the cases, when the civil nature case is some recovery of the amount is to be done, or some dispute is to be settled down between the tenant and landlord, and so many other motives which are clearly come to know that in so many cases we have seen that these false cases of rape and POCSO, definitely the minor girls are being used because of the stringent action of stringent law of POCSO is there, and that's why, and after some time, these cases are settled by after taking hefty amount of amount by the victims. That is also seen, and this has been noticed by these several trial courts also. So many rape cases are being settled, so many POCSO cases are being settled with while during trial they turn hostile, the victim turn hostile only after taking hefty amount or settling their score, whatever the motive may be. But this is really something very serious that the government should think about it, that all such false cases should be dealt with heavy hand, and the courts also must see when they find that these cases are being falsely sent for trial. They should also deal with this same hard-handedness. But the police is helpless. Police cannot decide that whether this is a false case or not. Police can only investigate the case and send it for trial. But one thing can be done. If such false cases are reported and the police sees during investigation the false case is there, then they may defer the arrest of the suspect or accused person. It is being done in so many cases. I have seen that when the police cannot stop the sending the case to the trial, they will have to send the case to the trial, but they can defer the arrest and the charge sheet can be filed without arrest also. And I have seen in so many cases when the police find that this is a case of false implication, then definitely some police officers use their mind and they do justice with the victim, the accused. Who they seem that it has been falsely implicated,
Right.
but they have to send the case to the trial. But in that case, I think that police as well as the trial court, they both should find out that if there are any false cases come to light, definitely that appropriate legal action should be taken against the complainant or the victim, whosoever is there. But definitely the false cases, in that false cases, it should be done. But in so many other cases, when the real cases POCSO is there, definitely there, then the law should take its own course, and the appropriate action should be taken against the accused person. This applies with both when the false case is there or the actual case is there, definitely, Krishna.
Right. Professor Alok Sharma, there was even a movie made on this in Telugu called Court, which released last year. It has become such a big, socio-cultural issue. A social issue that even movies get made about it as well. And clearly, there's so much of trauma faced by young adolescents because of the misuse of this law. And it would be really up to, activists, especially women and child rights activists, to ensure that, while, the law exists for the prevention of the most heinous of crimes, which is, sexual violence against children. The same children are also given the right, so many of them have already been affected. They will need some kind of counseling. And more importantly, that arbitrary fear that the adolescents carry needs to be taken away.
Yeah, and like in normal cases also, this is the special thing about the sexual offenses. But in normal scenario also, if we see young people are there and they are the first time offenders, still the provisions are that even after held them guilty, they don't send to the jail, and Probation of Offenders Act is there, other benefits are there. So because you see, we all know that if a young person will go to jail or will go to these kind of observation homes, the situation can deteriorate. Not only the stigma, etc., but his future is also completely well ruined. So the point is, what I can see in this scenario is that definitely the parliament can think over the inclusion of the Romeo-Juliet clause, but because on the other hand, on both things we have to protect the rights of the children. But the clause can be inserted, but with the rider that it is for the court to see see, because in all cases the court will decide whether the offense is made out or not. Now in this scenario, the court will see whether it is a consensual thing or it is not. But again, what I say is, when we say that marriageable age is 18, why? Because we say that the body of the female is not, fit for marriage or for having any such kind of relationship prior to 18. So biology always remain the same. So the kind what ma'am Jyotika ma'am was also saying, that we have to reconcile the law. So if one provision is there in one law, we say 18 is the age where below this rape will be there, or marriageable age is 18, and on the other hand we allow it 16. How to reconcile the law? But still you say, in order to prevent the misuse, we can do two things. Number one,
Right.
a clause can be inserted with the rider that it is for the fact and circumstances of the case that judiciary will decide. And secondly, the people who misuse the law, stringent punishments will be given to them. Normally we see that provisions are there in law, but the courts hardly use any such provisions. So it should be implemented so that people will discourage from filing the
Right.
false complaints, that a balance can be made. Yes, Krishna.
Fair enough. We will leave it at that. Completely out of time here on this conversation. I'm going to